A major court fight just put one of the most dangerous carry traps in America under a spotlight. And if you carry in places like stores, restaurants, or parking lots, this one matters to you right now. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to show you could help you avoid a criminal charge over a place you walk into every week. Hit that button now. Here's what just happened. Hawaii passed a law that did two huge things. First, it created a long list of so-called sensitive places where licensed carry could be banned. Second, and this is the part that changed everything, it flipped the normal rule for private property open to the public. That means if you walked into a business, a shop, or a restaurant, the law treated carry as illegal unless the owner gave clear permission. In other words, no sign saying yes could mean you were the one taking the legal risk. That law got challenged in court in a case called Wolford versus Lopez. Then the Ninth Circuit stepped in and made a split decision. The court said Hawaii could likely keep some location bans, including bars, restaurants serving alcohol, beaches, and parks. But it also said other bans, like bans at financial institutions and some parking areas, were likely unconstitutional. Most important of all, the Ninth Circuit let Hawaii's private property default rule stand. Source. Now, let me break down why that matters so much to you. Most people hear private property and think, okay, that must mean somebody's house. But that is not what this fight is really about. This fight is about the places you enter every day: the gas station, the hardware store, the diner, the pharmacy, the grocery store, the places that are privately owned but open to the public. Hawaii's rule basically said your carry permit does not help you there unless the owner clearly says yes. The DOJ later argued that this setup acts like a near-total ban because normal life almost always puts you on private property open to the public, and most owners do not post signs either way. So even if you are trying to follow the law, you can still walk into a trap. Source. Think about that for a second. Imagine you park your truck, step out and walk into a sandwich shop on your way home. You have your permit, you passed the background check, you trained, you believe you are doing everything right. But under a rule like this, you could be carrying illegally just because the owner never put up a sign giving permission, not because you threatened anyone, not because you broke the peace, just because the state changed the default rule. That is why people call this location-based abuse. It lets the government shrink your right by carving up ordinary life into little legal minefields. And here's the crazy part. The Supreme Court has already agreed to review the most important question in this fight. On October 3rd, 2025, the court granted review in Wolford v. Lopez, limited to the question of whether a state can make it a crime for a licensed concealed carry holder to bring a handgun onto private property open to the public unless the owner gives express authorization. Then the case was argued on January 20th, 2026. So as of right now, this is not some random internet rumor. This is a live Supreme Court case about whether states can turn everyday businesses into default no-carry zones. Source. First thing you need to understand is this. This case is not asking whether every gun ban everywhere is automatically illegal. That is what a lot of people get wrong. Even the Supreme Court's Bruin decision said some true sensitive places can still be off limits. Schools are the easy example. Government buildings are another. The real fight here is over how far a state can stretch that idea before it swallows your right whole. If a state can say bars, beaches, parks, banks, restaurants, stores, and most private businesses are all off limits by default, then what is left of public carry in the real world? That is the question hanging over this whole case. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now this is where it gets even more interesting. The U.S. Department of Justice did something that shocked a lot of people. It filed an amicus brief supporting the challengers on the private property issue. In plain English, DOJ told the Supreme Court that Hawaii's affirmative consent rule is unconstitutional. Their argument was simple and powerful. In America, the normal rule has long been that if a business is open to the public, you can enter unless the owner tells you not to. Hawaii flipped that and made carry illegal unless the owner clearly says yes. DOJ said that kind of clear statement requirement does not apply to other constitutional rights, and that Hawaii cannot wipe out public carry by changing the default rule. The brief even says the law functions like a near-total ban, because daily life keeps taking people onto private property open to the public. Source. When I found that out, I couldn't believe it. Because for years, a lot of gun owners assumed the federal government would stay out of fights like this or lean the other way. But in this case, at least on this issue, DOJ is saying the line has been crossed. That does not mean DOJ is endorsing carry everywhere. It does not mean every location ban falls tomorrow. But it does mean one of the most powerful legal voices in the country is telling the Supreme Court that a state cannot make ordinary public-facing businesses default no-carry zones. Second, there is a big state coalition backing the challenge too. Montana's Attorney General announced that a 27-state coalition asked the Supreme Court to reverse Hawaii's rule. The coalition argued Hawaii flipped the long-standing default on its head, and that the Ninth Circuit created a split with the Second Circuit over a nearly identical New York-style law. In simple terms, one court said this kind of default ban can stand, and another court said a similar setup should be blocked. That kind of split is exactly the kind of thing the Supreme Court often steps in to resolve. Source. But wait, there's something even more important. Not all states agree. Back in the Ninth Circuit stage of this same fight, California Attorney General Rob Bonta joined 18 attorneys general in support of Hawaii's authority to restrict carry in places like parks, banks, and private property without consent. So when you hear somebody say, the states back it, be careful. Some states backed Hawaii's restrictions. Other states backed the challenge against those restrictions. That is why this case matters nationwide. It is not just about Hawaii anymore. It is becoming the test case for how far states can go after Bruin. Source. Here's a hypothetical example to explain this. And let's say your state copies Hawaii's rule tomorrow. You leave home with your permit and stop at 4 places. First, a gas station. Second, a grocery store. Third, a dry cleaner. Fourth, a burger place. None of them post gun signs. Most people would assume no sign means no problem. But under a flipped default rule, no sign might mean the opposite. It might mean carry is banned unless the owner gave clear permission. Do you see how easy that is to mess up? That is the kind of ordinary person danger sitting underneath all the legal talk. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Third, let's talk about what the Ninth Circuit actually did, because this part gets twisted online all the time. The court did not say Hawaii can ban guns everywhere. It did not say every location rule is valid. It drew lines. It let some restrictions stay for now, like bars, restaurants serving alcohol, beaches, parks, and parking areas next to those places. But it also left in place an injunction against bans at financial institutions and some shared parking lots. So the real story is not total win or total loss. The real story is that courts are still trying to decide where the sensitive place idea ends and where ordinary public carry begins. Source. And here's the part nobody's talking about enough. Even if the Supreme Court rules against Hawaii on the private property issue, that does not automatically erase every location ban in every state. You still need to watch your own state's statutes. You still need to know local restricted places. You still need to understand posted sign rules, vehicle rules, and duty to inform rules where you live. A big Supreme Court ruling can set the constitutional limit, but the cleanup in lower courts and state legislatures can take time. That means confusion. And confusion is where good people make bad mistakes. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first and click subscribe right now. Fourth, let me explain why this case could become a massive reset. If the Supreme Court says states cannot force an express permission rule on businesses open to the public, then a lot of copycat laws around the country become much harder to defend. That would not create permitless carry in every business. It would simply restore the older idea that a lawful carrier may enter unless the property owner says no. That still respects private property. It just puts the decision back where many people think it belongs. That's with the owner, not the state. The owner can post. The owner can ask you to leave. The owner can forbid carry. But the government cannot start from the assumption that your right disappears the second you step onto private property open to the public. That is the heart of the challenge in Wolford. Source. Fifth, here is what most people get wrong about the phrase sensitive places. They hear it and think it means any place where people gather. But if that becomes the rule, then almost every place becomes sensitive. Park? Sensitive? Restaurant? Sensitive? Bank? Sensitive? Beach? Sensitive? Store? Sensitive? Transit? Sensitive? Event venue? Sensitive. At some point, the exception swallows the right. That concern showed up in this litigation in a very real way because Hawaii listed many everyday places and changed the default for private businesses too. That combination is what made people say the permit becomes almost useless in ordinary life. Source. Sixth, do not make the mistake of acting like this case already changed your law today. As of April 10th, 2026, the Supreme Court has heard the case, but the final opinion is still what everyone is waiting for. So if your state has a posted sign rule, a private property restriction, or a sensitive place law on the books right now, you still have to follow it until a court says otherwise. I know that is frustrating. I know people want a clean answer right now, but the safe answer is simple. Carry smart. Check current state law. Watch for updates. And do not assume a headline equals a final win. Source. Let me give you one more real-world scenario. Imagine you are on vacation with your family. You stop at a beach town, grab snacks from a small market, and walk across a parking lot shared by several businesses. In a state with broad location bans and a flipped private property rule, that short 10-minute stop can create 3 different legal questions. Was the market private property open to the public? Was there express permission? Was the adjacent parking area covered too? That is exactly why this case matters beyond courtrooms and legal briefs. It matters because regular people cannot live normal lives if the rules are so broad that nobody can tell where lawful carry ends and a criminal charge begins. Laws change fast, like really fast. Subscribe now so you're never caught off guard when a new ruling drops, because the next video will break down exactly what you should do the day this decision comes out. So here's the bottom line. The big fight in Wolford v. Lopez is about whether states can turn normal businesses into default no-carry zones unless the owner gives express permission. The Ninth Circuit let Hawaii keep that rule, but now DOJ and a 27-state coalition are telling the Supreme Court it goes too far, while other states still defend broad location bans. Source, 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 source. If you care about carrying legally and staying out of trouble, this is one case you cannot afford to ignore. Subscribe right now, stay with this channel, and I'll keep translating the legal mess into plain English you can actually use. And final reminder, this video is general educational content, not personal legal advice. Your state law, your facts, and your local courts still matter.